You took a subject.
For those of you on Zoom, we're going to start up in about 2 minutes. All right, good evening, everyone. Thank you to everybody who is here in person and those of you tuning in on Zoom. Hopefully everyone can hear me all right. My name is Josiah Rutledge. I am a Vice President of Speakers for our Federalist Society chapter here at Cornell. And it is my honor to introduce you to Professor Stiniford, who will be giving a presentation today on the original meaning of the Eighth Amendment to Cruel and Unusual Punishments Clause. Professor Stiniford is the Edward Rood Eminent Scholar Chair and Professor of Law at the University of Florida Levin College of Law. He researches, teaches, and consults in the areas of legal ethics, criminal law, criminal procedure, and constitutional law. His work has been cited by the United States Supreme Court, several state Supreme Courts and federal courts of appeal, and numerous scholars. It has been published in numerous scholarly journals, including the Georgetown Law Journal, the Northwestern University Law Review, the Virginia Law Review, the Notre Dame Law Review, and the William and Mary Law Review. Hopefully we can get in the Cornell Law Review at some point.
I was gonna get you about that actually.
Sorry to steal.
Whoever's on that editorial board. Yeah.
The Stanford Yale Junior Faculty Forum selected one of his articles as the best paper in the category of constitutional history, and the AALS Criminal Justice section named another article as the best paper in its Junior Scholars Paper Competition. In the fall of 2015, he was a visiting scholar at the Georgetown Law Center, Center for the Constitution. Before joining the Florida faculty in 2009, Professor Stiniford clerked for the Honorable James Moran of the United States District Court for the Northern District of Illinois, served as an assistant United States attorney, and practiced law with Winston and Strawn in Chicago. Professor Stiniford teaches first-year courses in criminal law and constitutional law, and upper-level courses in professional responsibility, criminal procedure, federal criminal law, law and literature, and white-collar crime. Everyone, please join me in giving a warm welcome to Professor Stiniford. We're turning it over to you.
Move the microphone over here so I can stand out of the light a little bit. Thanks so much for having me, Josiah. All of you, thanks for coming. You may be looking at this and thinking, wait a minute, this is not the talk I was supposed to come to. I think the talk on the advertisement was something like cruel and new, why the Cruel and Unusual Punishments Clause prohibits, lethal injection and solitary confinement and mass incarceration, but not the death or not the firing squad, something like that. This is that talk. This is just what I call it when I give it to judges, and I forgot to. I recently gave this talk to some judges and forgot to change the opening slide. But it's worth noting. What I'll be doing today, in part, will be to talk about the original meaning of the cruel and unusual punishments clause, but also to use this as an example of how, if one's interested in doing originalism, that is, doing the historical and textual research necessary to uncover the original meaning of a constitutional provision that might be otherwise obscure. This is an example of how one might go about doing it. So it's not easy. I always warn judges, don't try to do it on your own, right? You know, those TV shows, don't do this at home, kids, right? Don't have your law clerks like just try to, you know, research something up that you're not gonna have a good result. All right, well, let's get started. Do we have a, oh, I guess it'll go quicker, okay. Will it work? Is the question. Apparently not, okay, so I'll have to walk back and forth. All right. Here we go. Let me start with the problem that any judge has to face in deciding whether a punishment is cruel and unusual. And that is that the very purpose of punishment is to inflict pain. That's why we punish, is to inflict pain on people. And so as a constitutional matter, how do we distinguish between pain that is permissible, that's in fact the intended purpose of the punishment, and pain that is cruel and unusual, pain that is constitutionally impermissible? It's not an easy problem to solve if you think about it. Once you try to seriously figure out, how do I draw that line? It's not an easy line to draw. And so the court in recent decades has sort of taken two diametrically opposed approaches to this question for figuring out when intentionally inflicted pain goes over the line and becomes cruel and unusual. Now, the majority approach until recently, until really the last couple of years, has been the evolving standards of decency approach. So the majority would say that the Eighth Amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. So what does that mean? It means every day and in every way, society is getting kinder and gentler. And as society gets kinder and gentler, so too does the Eighth Amendment. So maybe a punishment would have been okay in the 19th century, but it's not okay today because we're much kinder and gentler today. That's the evolving standards of decency test. We look not to the standards of some time in the past, but rather to contemporary societal standards. If society today thinks it's too cruel, then it's too cruel, regardless of what people may have thought in the past. That's the basic idea. In contrast to that, Justice Scalia, when he was on the court, articulated an originalist approach, and I'm putting scare quotes around it because, and but I like Justice Scalia quite a bit, but actually, if you read his Harmelin versus Michigan opinion, which is his big originalist opinion, he falls into that trap of trying to do his own originalist research, and I think he got it very significantly wrong. And I'm going to talk about why I think he did today. But his basic approach was, if it was okay in 1790, it's okay today. So if a punishment practice was used at the time the amendment was adopted, then it must not be cruel and unusual, because what we care about is what the founders thought was cruel and unusual, not what people today think is cruel and unusual. That was his basic point. And he also said, by the way, and I'll talk about this a little bit later, that there's no proportionality principle built into the Eighth Amendment. That is, the only way a punishment could be cruel and unusual, according to Justice Scalia, was if it involved an inherently barbaric method of punishment. But it couldn't be cruel and unusual by virtue of being disproportionate to the crime. So, for example, a life sentence for a parking violation would not be cruel and unusual under Justice Scalia's approach, because we don't care about proportionality. We only care about whether this method is permissible at all, okay? So now that's, in a nutshell, the two basic approaches that have been sort of dominated the court in the last 50 years. One thing that's worth noting is that in a way, they're both the very same approach. Both approaches ask you to take a snapshot of public opinion at one moment in time, right? The majority says, what does public opinion say today? Scalia says, what did public opinion say in 1790? just a snapshot at one moment in time. And that's how you solve the problem, right? How do we know what's too cruel? Well, we look at what public opinion says at some moment in time, and then that will be our standard. And we just try and figure out whether something diverges from that standard, right? That's the way both sets of justices have approached the issue. Now, I'm going to argue today that both approaches are incorrect as a matter of original meaning. The evolving standards of decency approach doesn't even try to be correct as a matter of original meaning. It says we don't care what the original meaning was. We care about what people think today. I'm also going to argue that they're both unworkable in practice, that neither one is a good standard. If you just care about workability, neither one really works very well in practice. And so let's start with evolving standards of decency. As I said, it doesn't even try to pretend to be correct as a matter of original meaning. But what's wrong with it methodologically? What makes it a not very attractive standard to use? Well, there's a couple of problems. As I said, it doesn't even pretend to be based on the original meaning. The first is what I call the who decides problem. Who decides what current standards of decency are? Is it juries? Is it legislatures? Is it international opinion? The opinions of professional associations like the ABA? Is it public opinion polls? Is it hypothetical public opinion? Justices Brennan and Marshall famously used to talk about what the public would think about the death penalty if they only knew as much about it as the justices themselves do, right? Now, so it's very important to figure out what your source of data is. If you want to know what society currently thinks about something, you need to know where you're looking for your data. Juries and legislatures may make some sense because juries are drawn as a sort of a cross-section of the people themselves. Legislatures are elected to represent the people. But the court's never limited itself to those data sources. It's looked to these other sources as well at various times. And so there's not really any coherence, I should say, in terms of where the court gets its data as to what current societal standards are for punishment. The other problem is that this standard ties the meaning of the Eighth Amendment to public opinion. And public opinion and individual rights are not like chocolate and peanut butter. They are not two great tastes that taste great together. They're more like oil and water. The reason we have individual rights is to protect unpopular people and groups from public opinion. But if the Eighth Amendment only protects you when public opinion is turning in your favor and not when it's turning against you, then it's a meaningless right. It's an illusory right. It's a right that disappears as soon as the public turns against you. And I can tell you, anyone who has sort of lived through the last 50 years, as I have, and you guys have not for the most part, as far as I can tell, but you've lived through part of it, knows that the entire premise of evolving standards of decency is false. That is to say, it's not true that every day and in every way society is getting kinder and gentler. Sometimes we get kinder and gentler, but sometimes we get into a panic and we get harsher and nastier and angrier. And think about the last 50 years. In the 60s and 70s, there were public panics about crime rates generally. In the 80s, there were panics about drug crimes. In the 90s, there were panics about juvenile super predators. Basically, your generation was supposed to grow up and knife my generation to death in our sleep. Today, it's sex offenders. There's public panics about sex offenders. And every time there's a public panic about some group of criminal offenders, what do legislatures do? They dream up new and harsher punishments for those people, right? It's no mistake that we currently imprison more people than any other country in the history of the world, right? It's not because we're getting kinder and gentler. It's because the public is responding to panics about crime. 8 states, including the great state of Florida, currently impose chemical castration as a form of punishment for sex offenders. Okay, castration as a form of punishment was eliminated in the 13th century. We are literally getting medieval on sex offenders. Okay, but take a public opinion poll on that one, right? Will the public like it? Of course they'll like it, especially if they think it's going to make them safe. So tying the meaning of one of the core rights in the Bill of Rights to current public opinion is a disaster if you care about individual rights. So what has the result been in the court's actual jurisprudence? The result has been an Eighth Amendment that is both narrow and unprincipled. It's been unprincipled, especially in the area of the death penalty, because in the death penalty context, the court will periodically reach out and strike down some application of the death penalty by pretending to find a societal consensus against that punishment, even though there's really no plausible argument that there is such a societal consensus. For example, in 2008, in Kennedy versus Louisiana, the court struck down the death penalty for aggravated rape of a child. Take a public opinion poll on that one, right? Aggravated rape of a child. Even people who are against the death penalty might be in favor of it in that context. But the court says, no, no, no. And it uses, I'm not going to go through the various sleights of hand it uses to try and find a consensus against it. But the idea is, for the most part, by the time a case gets to the Supreme Court, you know, at least one legislature has authorized the punishment, at least one jury has imposed it. Very often, many legislatures have authorized it, many juries have imposed it. And if that's your main source of data about current standards of decency, then you're almost never going to be able to find that a punishment violates the Eighth Amendment, unless you play a game of pretend. And so the court has played a game of pretend in the context of the death penalty. It has not done so with respect to prison sentences. So in the context of prison sentences, unless there's a small category of sort of juvenile life sentences, juvenile LWOP, they call it, where the court has restricted that a little bit, although not as much as you probably think. Outside that, the court has said, hands off. We're not going to do anything about prison sentences. So, for example, in the 90s, the court upheld a sentence of 50 years to life for a man who was caught shoplifting videotapes on 2 occasions. He had a prior record, but 50 years to life for shoplifting videotapes. Okay, so the court said, we can't do anything. It's prison. We can't do anything about it. Now, why? Why won't they do anything with prison? Well, with respect to the death penalty, you know, you can like strike down the death penalty all day long. You could get rid of the death penalty altogether, and it would have no effect on public safety. Because even without court intervention, very, very few people get executed in this country. I don't think more than 100 people in a year have been executed since the beginning of the 20th century, if I remember correctly. At least since the beginning of the second half of the 20th century. So you can do it, no effect on public safety. If you got serious about restricting prison sentences, and you had to do so by playing a game of pretend, then all of a sudden you're letting thousands of people out onto the street using reasoning that's transparently fraudulent, essentially. And the court won't do that. And so the court has said, no, 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 we're hands off when it comes to prison. So that's the world we live in. The only people who benefit at all from the court's current jurisprudence are a very, very tiny group of offenders who have been sentenced to death. This is less than 1,001% of all felony offenders. The other 99.999% gets no benefit whatsoever. It's a very narrow approach to the Eighth Amendment. All right, so that's the evolving standards of decency approach, which has been the majority approach until very recently. What about the Scalia approach? So let's start with workability for Justice Scalia, because I'm going to spend the rest of this time talking about why I think he's also wrong as a matter of original meaning. The workability problem with Justice Scalia is this. In 1790, punishments such as whipping, bodily mutilation, and the pillory were considered acceptable forms of punishment. And Justice Scalia himself, shortly after he was elevated to the Supreme Court, gave a famous lecture at the University of Cincinnati Law School where he called himself a faint-hearted originalist. And he said, even I myself, if a legislature tried to authorize branding, they used to brand people if they committed certain crimes, so that when they went to a new town, everyone would know that they had committed that crime. If they tried to do that, even I would have to strike it down, he said, even though under my own theory, it should be okay because it was okay in 1790. Now, later in his career, he got less faint-hearted and he said, well, if the legislature did that, it would be stupid but constitutional, right? But the fact that the main proponent of this theory of interpretation himself would have a hard time enforcing it in practice indicates it's not a very attractive approach to the Eighth Amendment. Doesn't mean it's wrong. It could be correct but unattractive. But it's not a very attractive approach. It's not very protective. It may help in some areas where evolving standards of decency does not, but it's not clear it would. So not super attractive approach. Doesn't mean it's incorrect, but let's talk about that. I do think it's an incorrect approach. And I'm going to try and show you why. His problem is that he ignores the word unusual in the cruel and unusual punishments clause. And by the way, this is something else he has in common with the evolving standards of decency approach. If you read Trope v. Dulles, which is the first case announcing that approach, in both that case and in Justice Scalia's Harmelin opinion, they say, what is unusual doing here? I don't really know what it means. And so it probably doesn't really mean anything. I'm not going to really worry about it. And that approach, it sort of makes sense, right? Because if you're thinking about a cruel punishment, why should we care how unusual or rare it is, right? It would seem the more common it is, the worse, right? It would seem to be worse to sort of publicly torture all sex offenders as opposed to just publicly torturing some small group of the worst of the worst, right? Why should the rarer punishments be the ones that are more likely to be unconstitutional? And so the court and Justice Scalia have all sort of ignored the words and instead they have had this abstract "don't be cruel" approach to the Eighth Amendment. And so again, the assumption that he shares with them is that there's merely an abstract moral principle at play here, an anti-cruelty principle. Simply it's abstract, and then the difficult thing is figuring out how to apply the abstract principle to a concrete situation, right? And we've already gone through the ways that these sort of two approaches have tried to do that. I'm going to argue that this was a key mistake, that the word unusual actually does very important work in the Eighth Amendment, and that the mistake that both Justice Scalia and the evolving standards of decency court made is that they got the meaning of the word unusual wrong. They got the meaning wrong. So in the context of the Eighth Amendment, unusual does not mean rare or out of the ordinary. We're not talking about cruel and rare punishments. Instead, it means contrary to long usage. In other words, new or innovative punishments. Okay, that's what unusual means. I'm going to try and prove that to you today as best I can. And by the way, if I can't quite get there, if we don't have time, I do have a bunch of articles on this. The main one is the original meaning of unusual in the Northwestern Law Review. So if you're interested, you can read it, or if you have trouble sleeping, you can read it. It will help with that as well. So it means new or innovative, contrary to long usage. Unusual is a common law term that reflects the common law ideology underlying the Eighth Amendment and much of the Bill of Rights. So now, before we move forward, I'm going to ask for volunteers so I don't have to cold call anybody. Who can tell me what the common law is, or at least what you were taught it is in your first year classes? Yes.
Case method relying on precedent.
The case method relying on precedent, and who makes the common law?
The legislative courts, the judge.
Judges, right? Judge-made law, right? And that's, you almost got around my trap, but I forced you into it eventually. Judge-made law. This is what I was taught as a first-year student. This is what people are generally taught. It may be changing a little bit now, but generally taught. And this comes to us from Oliver Wendell Holmes, where he says the common law is judges making policy from the bench, right? That's what they do. They sit there on the bench. They think, what's the best public policy to cover this thing? And I will make law to cover it, right? And then they'll follow each other's precedents. So there's a little bit incremental and stuff, but it's basically judges making law from the bench. This is a lie. It is a lie that everyone has bought because Oliver Wendell Holmes has an impressive sounding name and big bushy mustaches. And he wrote very sort of quippy kind of opinions that people love to quote. But it's wrong. No one before Holmes ever claimed that judges have the power to make law. Critics of the common law claim that that's what was really happening, that they say, oh, the judges are really making it up as they go. But no one ever defended the common law on the ground that there was a judicial lawmaking power. That's a gift to us from Oliver Wendell Holmes. And it's had all sorts of distorting effects on the law, in my opinion. One of those distorting effects we'll see is our failure to understand what's going on in the Eighth Amendment, but we can at least hopefully correct that part of it today. So if it's not judge-made law, then what is the common law? Well, there's four key ideas underlying the common law. And the first is that the common law is the law of custom and long usage, not judge-made law, the law of custom and long usage. So the notion is when a judge is deciding a case at common law, the judge identifies the custom and then applies the custom to the case. Like this is what's sometimes called binding law. The Holmes mocked it. He said, well, there's no brooding omnipresence in the sky, right? That he thought that's what common law thinkers thought it was. But no, it was simply a custom. We have a longstanding custom. The judges identify the custom and they apply it in new cases. And of course, the custom develops over time because you're applying it to new situations, but it's not judges making law, it's a custom. Now, why is this important for our purposes? Well, this is before I have you read this, I know when I put things on the board, people read it. The common law thinkers, common law has been around for at least 1,000 years. And over the years, common law thinkers started thinking about the common law. They started thinking, what is this thing that is the common law? How can the common law be law, even though the king has never said thou shalt or thou shalt not? Parliament has never said thou shalt or thou shalt not. And yet somehow it's law. We have this thing, this unwritten law, we're enforcing it as law. How can that be? And so what common law thinkers the conclusion they reached was this, that when a legal practice is used for a very long time, this is evidence that it's reasonable and that it enjoys the stable multi-generational consent of the people. Otherwise, it would stop being used. And by the way, it had to be used universally throughout the jurisdiction. So it's used universally throughout the jurisdiction, that this is evidence that it's reasonable. And by the way, the word reasonable back then also didn't mean what you think it means. It meant it comported with principles of reason or natural justice. So they all believed in natural law. The problem with natural law is how do you figure out how to apply it in practice? Again, the customs of the people. The customs of a free people reveal as best as humans can determine what's reasonable over time. So multi-generational consent shows that it's reasonable and that the people consent. And if it's unreasonable, it falls out of usage. This is what's known as failing the test of time, right? We all use that term still. If it falls out of usage, it's failed the test of time. Okay, now why is that important? Okay, so you understand now this is why, so they say, look, this is why we can enforce it in a court of law. Because we know it's reasonable and it's just and it enjoys the consent of the people. Because of it, it enjoys long usage. That's sort of our guarantee that it meets principles of justice, and so we can enforce it, right? Now this, however, over time gained a new importance because the common law thinkers eventually started noticing, or at least arguing, that the common law is normatively superior. By the way, normative is just a fancy word for essentially morally superior to enacted law. That is, it tracks more closely to fundamental principles of justice because it does not become law until long usage has shown it to be good, whereas enacted law does not have the same guarantee of goodness. Okay, now this is, and again, just to give you a modern example, remember when the Affordable Care Act was passed and Nancy Pelosi famously or infamously said, we have to pass it so that we'll know what's in it, right? And everyone laughed at her and stuff. But like that's really true of every law. Even a short, simple sounding law, until you enact it and it starts getting enforced, you don't really know how it's going to work in practice. There's going to be unintended consequences. It may end up having very bad results that the legislature never wanted to happen, but just didn't foresee because human beings can't foresee. And so the common law thinkers saw Parliament doing this, where they would enact laws that were contrary to the common law and that would have bad effects. And they would say, wait a minute, this is not a good thing, right? The common law itself is our touchstone. It's the core sort of element of law that we know to be good. And so when the legislature passes a law contrary to the common law, we're going to be skeptical of it. And we see remnants of that today in some of our canons of construction. So for example, you may have heard of the canon that statutes in derogation of the common law are to be narrowly construed, right? And because that's the idea is that when you change things that have been around for a long time that have worked well, we're worried it's going to have bad consequences, so we're going to read it narrowly, right? In the criminal law, there was the rule of strict construction of penal statutes, which today is known as the rule of lenity, but it was originally the rule of strict construction of penal statutes. Again, similar idea. You have common law crimes, common law punishments. When the legislature is innovating, it's often doing so in a way that's much harsher than the common law would permit. And so we're going to construe penal laws as narrowly as we can, right? That's the idea. So this idea developed, it was broadly accepted in the legal culture in England and America that the common law was generally speaking closer to principles of justice than enacted law or law enacted by Parliament or in our case, Congress. So now, why is that important? Well, now we're finally getting closer to the nub of the Eighth Amendment. This idea that the common law is superior to enacted law is the very source of the idea that there are rights enforceable against the sovereign. In the English and American systems, this is where we get the notion that there are some things that even the king can't do. There are some things that even Parliament can't do. There are some things that even Congress can't do. Why? Because they are contrary to rights established at common law, right? And think of the American Revolution, right? What was the justification for the American Revolution? Things like no taxation without representation, or no deprivation of the right to a jury trial, right? These were core rallying cries. Where did those rights come from? Long usage. These were common law rights. And the English in the 17th century and then Americans in the 18th century argued that in some areas the common law limited the government's power because the common law reflected core principles of justice and the government could not deviate from those. Okay, that was the core idea behind the common law. Okay, now, so my argument is, just to sort of sum up where we are, common law is the law of custom and long usage, right? Common law becomes law when it enjoys long usage, that is, when it's universally used throughout the jurisdiction for many, many generations. My argument is that a governmental practice that is contrary to the common law is an unusual one, right? So long usage is the common law, unusual, contrary to long usage is what the word unusual means. That's my argument. And so when we think of cruel and unusual, we need to think cruel and new, or cruel and contrary to long usage, right? That's the argument I'm going to make. Now, you may be saying, Ari Steniford, that's very clever, but what's your evidence that in fact this text means that, right? You're drawing an inference from the way people talk about the common law to the meaning of the Eighth Amendment text. How do we know that the text actually meant that? And so, and particularly that the word unusual meant that. We actually have very good evidence. I want to start with evidence from England. So England was the first country that used the phrase cruel and unusual punishments. They used it in the English Bill of Rights about 100 years before the American Bill of Rights. And we have very good evidence of what the phrase meant in England because of a man named Titus Oates, okay? Now, Titus Oates, as the slide indicates, in 2005, he was voted the worst Briton of the 17th century and the third worst Briton in the past 1,000 years. But I love Titus Oates, yes?
You happen to know who the worst Briton of the past 1,000 years was?
I'm not, I knew once, but this is a long time ago, maybe Jack the Ripper, I'm not sure. It was something like that.
Maybe Cromwell.
Maybe Cromwell, maybe Margaret Thatcher. I mean, who knows? I mean, I like Margaret Thatcher, but some English people would probably say that she was the worst. So maybe Boris Johnson now, who knows? Let me talk about Titus Oates, though. So Oates was a 17th century Anglican clergyman. He was down on his luck. He had some trouble with the law. And he was kind of like a 17th century Kardashian. Like he really wanted fame and fortune. That was what he was all about. And so he thought, how can I get fame and fortune for myself? And he thought, well, you know, people really don't like Catholics very much. Everyone's always worried that the Spanish Armada is going to come sailing up the Thames. And so if I come up with a popish plot to kill the king, and I expose the plot, then I'll be a hero, and everyone will love me, and I'll have fame and fortune. So this is exactly what he did. He went to a magistrate in London. He said, there's a popish plot to kill the king. He implicated 15 people, including the Queen's physician. 10 days later, the magistrate shows up dead in the streets of London, right? Okay, so now it's Panic at the Disco, right? Like the Catholics are here, right? They're coming, you know, what's gonna happen? And so they immediately sort of round up all the conspirators and they start having trials. And it's like, you know, trial, conviction, execution, trial, conviction, execution, until we get to like the 15th trial, at which point Oates' story unravels. It becomes clear there was like a key meeting of the conspirators that he claimed to have been at in England. There's actually proof that he was at that very time was in France enjoying some wine and cheese with his buddies, and that there was no meeting of the conspirators. And everyone suddenly realized that they'd been duped and there was no conspiracy. If they'd even thought about it, it would have been weird for there to be a conspiracy because the king was Charles II, who was actually quite friendly to Catholics. So like, why would they be trying to kill him? Although his brother was a Catholic, so maybe, but anyway. So they realized that he's lied to them. And so they immediately arrest Oates. And you can think like Oates is like sort of like a serial killer, right? Like he kills 15 people intentionally and premeditatedly. He's worse than your average serial killer because he doesn't even have a compulsion to kill. He just wants fame and fortune. But under English law at the time, the only crime he was guilty of was perjury resulting in death. And that was a misdemeanor under English law. So he gets tried and convicted on 2 counts of perjury resulting in death. And then he's up for sentencing. And he's in front of Chief Justice Jeffreys, the famous hanging judge in English history. And Jeffreys says, you know, Mr. Oates, this is a misdemeanor, so we can't take your life, we can't take your limb. By the way, this is all published. You can read the trial of Titus Oates, it's all been published. Can't take your life or limb, but we have something special planned for you. And I think that's almost a direct quote. We have something special. He handed it off then to Justice Withens, I believe, who pronounced the sentence. And these pictures kind of represent the sentence. So he was fined 2,000 marks, which was a lot of money back in the day. He was sentenced to be flogged while being dragged across the city of London from Aldgate to Newgate. And then 2 days later, just as the wounds were starting to heal, dragged again across the city of London from Newgate to Tyburn while being flogged. Many people think the hope was that he would die from the flogging, but like a cockroach in a nuclear war, he survives, right? He's sentenced to be pilloried 4 times a year for life. This is the actual wood carving of Oates in the pillory. So they would make these wood carvings and then make postcards out of them. So like they didn't sell them. So he had to go in the pillory 4 times a year for life. And he life imprisonment, and then he was defrocked. So that was his punishment. That was Oates' punishment. So they send him off. 5 years later, Charles II dies. His brother James II has become king. Everybody hates James because James is a Catholic. So they depose James. They invite William and Mary to come over in the Glorious Revolution as king and queen. And this is the first time that Parliament bestows the crown on someone. And they say, William and Mary, we'd like you to be our new sovereigns on the condition that you accept this new thing we've written up called the Bill of Rights. And if you'll accept this Bill of Rights, then we'll make you king and queen. And of course, they're just, you know, they're measuring the drapery at Windsor Palace. So they're like, sure, you know, we'll sign. So they sign it. One of the rights in the Bill of Rights is, it says there shall be no cruel and unusual punishments. This is, again, the first time we see this phrase. It gets passed. And who shows up in Parliament the next year but Titus Oates? Titus Oates. He says, hey guys, you know, good job. Like, I didn't like those Stuart kings either. Good job getting rid of them. By the way, the punishments imposed on me were cruel and unusual. So please lift the judgment. Now, you can read it, and the debates in Parliament are also published. You can read them. If you read the debates, it's clear that a majority in both the House of Commons and the House of Lords considered this punishment cruel and unusual. In fact, members of the House of Commons said they were thinking of Oates specifically when they drafted the cruel and unusual punishment provision. But the House of Lords would not lift the judgment. And this is, again, almost a direct quote, because so ill a man should not get the benefit of our shiny new Bill of Rights. So he doesn't, so they refuse to lift the judgment. I love getting laughter for this. So they won't lift the judgment. But if you read the debates, what's interesting is, you know, what they say about why it's cruel and unusual. They say it's contrary to law and ancient practice. It's without precedent, and it'll be a bad precedent for the future. And of course, it's exorbitant and extravagant and barbarous, right? But notice what they say, right? Not that it's just cruel, it's contrary to law and ancient practice. It is unusual, contrary to long usage, right? So this is how we know it crosses the line, because this is more than the common law, significantly more than the common law has ever before permitted for the crime of perjury, right? So in England, I think it's quite clear that unusual in this context means contrary to long usage. It means we know that it's cruel because it's significantly harsher than long-standing prior practice would permit. One other interesting thing about oaths is that it also makes clear that at least in England, there is a proportionality principle built into the Eighth Amendment, contra Justice Scalia. Because if you think of the punishments that were inflicted on oaths, every one of them, except for the defrocking, was a common law method of punishment. It was not considered an inherently barbaric method of punishment. They were all done at common law. Also, even if you add them all up together, like to sort of look at the harshness of them all together, they were not as harsh as some other punishments that were permissible in common law for other crimes. Like, for example, for treason, you could get drawn and quartered, which is a very gruesome way to be executed. And I'm not going to go into details now, that's what Wikipedia is for. But trust me, it's worse than this, right? So if this is cruel and unusual, it has to be because it's disproportionate to the crime of perjury, right? Because as an absolute matter, it's not unduly harsh under the common law. So anyway, so that's oath. But again, you might be thinking, all right, that's fine. That's England. Didn't we have a revolution to get away from these people, right? Like, why should we think that it means the same thing in America that it meant in England? And there's actually lots of evidence of this. And again, this is something where I'm going to have to briefly summarize, but you can read my articles if you want to get more evidence, or I can talk about it in Q&A. First of all, if you look at rights talk during the Revolution, so during the American Revolution, the word unusual was repeatedly used as a synonym for unconstitutional or contrary to law usage. So unconstitutional meaning contrary to the English Constitution, which was a customary constitution, common law constitution. So for example, the Virginia House of Burgesses sent a formal complaint to the king saying that taking away the right to jury by trial was unusual, meaning that it was contrary to long usage. So that the Americans during that period used the word unusual in that sense. Also during the ratification debates, the word unusual got used in that sense. So for example, Patrick Henry, in his complaint against the Constitution itself, he didn't like the Constitution itself because Congress would not be bound by the common law. And he said the whole thing is nothing but a series of new and unusual experiments. And he said, you know, would you want your physician to give you new medicine? No, you wouldn't. You want tried and true medicine. So unusual, meaning new, contrary to long usage, right? So in both of these contexts, the word unusual is used in that sense. Also, early post-ratification cases. So if you read, there's no early federal cases. There's a bunch of state analog cases because the states had their own constitutions, which had most of which had some version of a cruel and unusual punishment clause. And time after time, when they're trying to figure out whether a punishment is cruel and unusual, they would compare it to longstanding prior practice. They'd say, how does this compare to the tradition? And if it's harsher than the tradition would permit, then we can say it's cruel and unusual. And finally, remember the thing I told you at the beginning about Americans and the common law. We were, if anything, we were more devoted to the common law as a source of rights than were the English themselves. By the time the American Revolution happened, England was moving towards a system of parliamentary supremacy, where Parliament can do anything, including eliminating Magna Carta, eliminating any right it wants. That's still the system they have today. I mean, a simple majority vote of Parliament could eliminate anything, habeas corpus, what you name it. But in America, Americans resisted that idea. In fact, in some sense, that's the whole source of the conflict that led to the revolution, where Parliament was saying, we can do what we like. We can take away your common law rights because we are the sovereign. We can do what we want. Sort of like Cartman in South Park, right? Like, respect my authority. I'll do what I want. And Americans are saying, no, you're bound by fundamental common law rights, right? Like that's the notion. Okay. So now, if I'm correct, what does this mean? What will this do for us in terms of today's current situation? So first of all, if in fact cruel and unusual means cruel and new, This is a sign that it's the job of the judiciary to prevent drastic increases in the harshness of punishment, not to put an end to older practices it no longer likes, right? It's there as a guardian. Remember I told you the last 50 years has been a series of panics. And every time there's a panic, we ratchet up punishments to new and unprecedented levels of harshness. Judges are there to prevent that under the Eighth Amendment, right? They're there to say this new thing, 50 years to life for shoplifting. How does that compare to the tradition? If it's significantly harsher than the tradition would permit, then we can strike it down as cruel and unusual. And we're not having to play any games. We're not pretending to find a societal consensus. We're simply comparing what we're trying to do now to our longstanding prior practice. And if it's much harsher than the prior practice would permit, then we can strike it down. And by the way, I would suggest that this is where the real danger is that we need judges to protect against, is when there's some panic or when the government's out to get some enemy and they respond by ratcheting up punishment to new and unprecedentedly harsh levels, right? That's where judges are supposed to be doing their job, but they can't do it under evolving standards of decency, because if the public's in a panic, then the public will love whatever you do, right? Anything that shows you're in control, they will love. Long-standing prior practice then is the baseline against which to measure the cruelty of the punishment, right? So we don't look to today's standards, we don't look to the standards of 1790, but rather we look to multi-generational consensus, the tradition over the past multiple decades, right? This means that there is a principle of legal development built into the Eighth Amendment. So this is a quote from Edward Coke, maybe the greatest common law thinker in England. He said, "Custom loses its being if usage fails." Now, what does that mean? Well, again, it's similar to our phrase today, failing the test of time. If a punishment falls out of usage and stays out of usage for a long time, then it's no longer part of the tradition because it failed the test of time. And so if the government tries to bring it back, then it's now a new punishment, and it has to be compared to the tradition as it survived up to today. And notice this solves Justice Scalia's faint-hearted originalism problem, right? Why isn't it okay, probably, to brand criminals or to bodily mutilate them in some way? Well, because those punishments fell out of the tradition centuries ago. And if you try to bring them back now, they're now new. They're not part of the tradition, right? So the tradition is not about identifying something that existed 2 centuries ago and saying if it existed then, it must be okay today. Rather, it's the tradition as it survived over time. That's what the common law is all about. What the great metaphor for the common law that was repeated over and over again was that it was like the ship of the Argonauts that replaced every single board on the ship. And yet it was still the same ship, right? Over time, it renews itself. The tradition develops over time. But you always have that ballast of sort of multi-generational consensus to keep us tied to the core values of our culture, right? That's the basic idea. So as I just said, this means that old punishments that fall out of usage for multiple generations are no longer part of the tradition. Also, new punishments might become part of the tradition if their cruelty is not immediately obvious and if they achieve universal reception that's sustained over a period of multiple generations. And so just one example would be prison. Prison was basically a new form of punishment in 1790. It didn't exist. You were typically, if you were going to be punished, you would get some kind of corporal punishment like a flogging. You might be fined monetarily. In an extreme case, you might be subjected to the death penalty, but you weren't imprisoned as a form of punishment. You might be held in a jail prior to punishment, but after punishment, you weren't imprisoned. So that was new. But it became universally accepted, and it's now survived for 2 centuries. You could probably say, at least as a method of punishment, it's now part of the tradition. Now, that doesn't mean that every single prison sentence is constitutional, right? If we're giving someone 50 years to life for shoplifting, that hasn't been universally accepted for 2 centuries, right? We can still look at that. That's a proportionality question. But the method itself now is probably okay. So a few current applications, and then I'll open it up to questions. First of all, the death penalty. So what does this mean with respect to the death penalty? It means that the courts are not empowered to sort of selectively strike down instances of the death penalty that they no longer like. They're not empowered to completely eliminate the death penalty either on their own. That's not what the Eighth Amendment directs them to do. On the other hand, if a particular application of the death penalty was eliminated a long time ago and it's brought back now, the court might appropriately ask, is this still okay? Is this still part of the tradition? And I'll give you one example. The first Congress authorized the death penalty for counterfeiting. Okay, now today counterfeiting is still a felony offense, but it's a relatively minor in our constellation of felony offenses. So if Congress tried to bring back the death penalty for counterfeiting, the court now would have to say, well, how does this compare to how we've treated counterfeiting for the last 2 centuries? And if it's significantly harsher, then we could say it's now cruel and unusual, even though it wasn't in 1790, right? So there is a principle of development, but it's not judges who are driving the development, it's the people themselves. If the people themselves, through legislatures, prosecutors, juries, stop imposing a punishment, then it's no longer part of the tradition. And judges can recognize that later after it's happened and been sustained for a very long period of time. Lethal injection, I'll leave the details of this for Q&A if anyone wants to talk about it. I think lethal injection, as is currently imposed in most states, is very likely cruel and unusual. I think it's very likely, and I'm happy to talk about why, but it's a new method of execution that I think is actually much harsher than hanging or the firing squad in its effects. And so, I think it's probably cruel and unusual, even though the public perception of it is that it's like putting an animal to sleep. It's not like that at all, actually. Long-term solitary confinement, I think, is also probably cruel and unusual under the original meaning of the Eighth Amendment. And I'm happy to talk about why that is as well. I've written an article on it, but I can talk about that more. And also, mass incarceration, the reasons for mass incarceration are very complicated, and people dispute really what they are, and I can't pretend to know what they all are, so I can't claim that a return to the original meaning of the Eighth Amendment will solve mass incarceration. But at least, to the extent that one reference point might be this. In 1970, there was something like 300,000 incarcerated people in this country. Today, there are 2.25 million. Now, if you just sort of looked at population growth, you would expect that if we kept the same rate we had in 1970, which was the rate we had had for a long period of time before that, you would maybe have 600,000 incarcerated people now. We have 2.25 million. So there's been an explosion in incarceration. The reasons for that, as I said, are complicated, but at least part of it seems to be longer sentences. Today we have more than 500,000 people serving life sentences, right? So almost double the total number of incarcerated people in 1970 are now not only incarcerated, but serving life sentences, right? And we know at least some of them are doing so for relatively minor offenses. So I think the courts, again, could appropriately, this would have to be more of a crime by crime basis, as it were, right? Like how have we treated this offense in the past? What are we doing with it now? But I think at least at the margins, we could have some amelioration of mass incarceration if the court paid close attention to the original meaning of the Eighth Amendment. Also, some other areas like strict liability, what are sometimes called regulatory crimes. You probably cover these in your criminal law class, where this is sort of a creature of the 20th century, where all of a sudden we start punishing people even though they have no moral fault at all. Like there's no mens rea, there's nothing. They just happen to hold the job of, that had some supervisory role in theory. And so now they go to prison, sometimes for a very long period of time without any proof of culpability. That might be cruel and unusual, because the tradition of prior to the 20th century, the universal tradition in both America and England was you had to prove not just that someone did the act, but that they had some requisite level of culpability. And so again, that might be unconstitutional. And so that's the upshot if the court were to accept this particular take on the original meaning of the Eighth Amendment. And so now I'd love to hear anyone's questions. Yes.
If tomorrow the court were to adopt this new perspective,
Yeah.
We've had coming up on a century of a different interpretation of the usual and cruel punishments. Which cultural zeitgeist of appropriate punishments do we go back to? What's the date at which we kind of assess these issues?
Yeah, I mean, so this is a tougher question in some contexts than in others, right? So, because the court has basically taken a hands-off approach to prison, for example, that it's, the custom has been unimpeded by the court, right? So that's probably okay. One area that's especially difficult will be actually the death penalty itself, right? Because if you think about it, like in Coker versus Georgia in 1977, I think the court says you can't impose the death penalty for rape, right? That's Coker versus Georgia. And they had previously struck down all death penalty statutes, right, in 1972. And so you're starting in the 70s, right? You have the situation where legislatures start reimposing the death penalty, and they might want to reimpose it for a broader range of crimes. But they know that if they go beyond like murder, basically, then the court's going to strike it down. And so you have half a century now where it's just murder, basically. That's a capital offense. What do you do about that? Is there now a custom of only murder, right? I think that can't be right, because the custom is supposed to reflect the values and traditions of the people, not sort of an ipse dixit from the court. And so I think you'd have to say, you could look into the tradition up to the early 1970s, certainly with respect to the death penalty. And then you probably have to let things work through the democratic process for a while before we have some new consensus and see how that consensus lasts over time. So again, it's not an easy or quick solution to some problems like that. When you have an incorrect interpretation that's frozen things for a certain period of time. Yes.
How long does something have to be out of common law practice for it to be out of tradition? And who decides that?
That's an excellent question. And so it's a, Justice Scalia would hate the answer, by the way. It's kind of a factor test. So, because remember, so when the legal concept is called desuetude. So if you want to look it up, it's DESUETUDE. And the notion is that if a legal practice falls out of usage for a long period of time, then it's no longer law, right? And sometimes with respect to statutes, but also common law. But how long it has to take depends on a variety of factors. And so the legal thinkers who've written about this have said, one factor would be how often has there been an opportunity to use it? So if we're talking about the death penalty for rape, for example, well, there's opportunities all the time because there's all sorts of rape trials all the time. If it's the death penalty for treason, on the other hand, I mean, maybe you only have a treason trial once every 20 years, every 50 years. And so a century of non-usage for rape would be much more indicative that the death penalty is no longer part of our tradition for that crime than a century of non-usage for treason, because you only have a couple of opportunities. So that's one factor. How often was there an opportunity to use it? Another factor would be, is there evidence of strong societal division during that time period, right? So if it's the case that it's out of usage for a long period of time because exactly 50.1% of the people in power don't like it, but throughout that time, there's a strong clamor from the other 49.9% to bring it back, then again, thinkers have said maybe you need a longer period of time before we can say it's out of usage, right? So again, you think in terms of universality, think in terms of, again, opportunities for use. So that's the consent. There's probably a few other factors which I'm not remembering. I actually wrote an article on this one called Desuetude and Original Meaning. So if you're interested, look it up. And again, I promise it'll help you sleep. The other thing I will say, in the context of the Eighth Amendment, there have been a couple of cases where the court seems to draw on this concept. And the implication from those cases seems to be that it has to be like at least a century or so of non-usage. So there's a case of, what was the case called? It was out of Utah, Wilkerson versus Utah, where the Wilkerson was going to be executed by firing squad. And he tried to argue that the firing squad was an unconstitutional method. The court quickly said, no, this is a traditional method, it's fine, it enjoys long usage. But then in some interesting dicta, it says, however, we've noticed that when Blackstone talks about the death penalty, he talks about all the nasty things they would do in England before they would execute you. Like they would, they'd beat you up and they'd strangle you, and and only then would they execute you, right? And the court says all those other things that are sort of super added, the terror and pain, super added on to the death penalty are no longer part of the tradition because they haven't been used for a century or more, right? And so the court says that fell out, and we know it fell out because it's been gone for a century. There's a few other cases like that, and it always seems to be about a century. And so I think the rule of thumb would be if it's a regular crime where there's going to be regular opportunities to use the punishment, and 5 generations find no need to use it, then and they don't want to use it, it's not part of their tradition, then we can say it's no longer part of the tradition. I think that's, sorry for the lengthy answer, but that's the best I can do. Lots of hands. I'm not sure who was first. I guess Josiah invited me, so I'll do Josiah.
I've got plenty of questions of my own, but since I get to go to dinner with you, I'll go with one from the YouTube feed. This one's actually from my boss for my summer job. So hi, Randy. And he says, this is interesting because it suggests that the meaning of the cruel and unusual punishment prohibition is fluid as an originalist matter, but that seems in tension with one of the things that many people find appealing about originalism, namely that the meaning of the Constitution is fixed. So could you speak a little bit on fluidity versus rigidity of meaning as a matter of originalist matter?
Yeah, and so thanks for the question. It's an excellent question. So when we think about meaning, I think people use the word meaning in several different senses. And so I think when we talk about original meaning, the core of it is the semantic content of the text. That is, what does the word mean, right? When we sort of how would we define the term? So the semantic context of cruel and unusual punishment does not change, has not changed over time. So cruel means unjustly harsh, unusual means contrary to law and usage, and of course punishment refers to punishment, right? But there sometimes a word refers to a state of the world that itself changes over time. So unusual means contrary to the common law. But common law thinkers themselves all universally agree that the common law changes and develops over time as practices fall out of usage and new practices come into usage. And so so if we're going to be true to the original meaning, we have to recognize that it's referring to something in the world that changes. So that's not changed meaning at all. So obviously it doesn't give you, I think that, the dream that originalism will give you a fixed answer, like this sort of WWMD, what would Madison do, right? Like, and that's all we have to figure out. And like, if we can figure that out, then we're okay. Like that's, in a way, it's a child's hope, right? Like no one can ever get that from the Constitution, nor should they try, because that's not what law is. So but it's important that we understand what the semantic content is. The semantic content does bind us. That is, we have to follow that content. We can't say, well, I don't like long usage as my standard. I prefer current societal standards instead. Well, but that's not what the semantic content of the text directs you to do. And so if you're a judge who's taken an oath to enforce the Constitution, you have to enforce that original meaning. But again, it's a meaning that may refer to a state of the world that develops over time. I hope that answers the question. Yes.
I wanted to just first of all get your take on lethal injection. I think I am one of those people who assumes it's a syringe and then you fall asleep. So I'm having trouble with how that could be worse than hanging. And then I also wanted to know, if not lethal injection, what in your opinion is the most humane option?
Okay, so the last, I'm not sure I can give you the last one because I'm not an expert on methods like in that sense. I've not done studies. So because it would violate ethical principles among other things. Okay, I'm going to kill you now, but I want to see how much it hurts first. But look, seriously, and this is, I'm going to get a little soapboxy here for a minute. There's a few things I'd like to say about this, and some of it's a little bit gruesome. So my apologies. Some of you, I think, were reacting when I was describing some of the punishments earlier, but it's important to understand if we want to understand why lethal injection may be unconstitutional. So everyone agrees that if you just injected people with barbiturates, just gave them a lethal overdose of barbiturates, they would die painlessly. That's how animals are put to sleep, right? That's not what we do. Typically, states use a 3-drug cocktail that has involved barbiturates, but also a heart-stopping agent and a paralyzing agent. And it's important to understand the reasons why the state uses these other agents. if you just use barbiturates, two things would happen. First of all, it takes a long time for someone to die from barbiturates, right? It could be an hour or more before they die. And so they give the heart-stopping agent to make it quicker. Also, if you just use barbiturates, they would go through the death throes, if you're familiar with that, where the body convulses just before death. And that looks violent, that looks bad. And so we give the paralyzing agent to eliminate the death throes. Okay, so notice that 2 of the 3 drugs in the 3-drug cocktail are given for purely aesthetic reasons. Purely to make it look like we are not killing someone, when in fact we are killing someone. Okay, now what's the problem with this? Okay, well, the problem is that if the barbiturates are not properly administered, then the other 2 drugs will cause excruciating pain. So the heart-stopping agent has been compared to having liquid fire poured into your veins. Of course, the paralyzing agent forces your lungs to stop breathing. So you're conscious, but you can't move your lungs. So imagine simultaneously drowning and being burned to death from the inside. Okay, that's what happens if the barbiturates are not properly administered. There is evidence, and I don't know whether this is accurate, it's the only study I've seen on it, but there's evidence that the botch rate, that is the rate at which lethal injections are botched, is more than triple the botch rate for hangings. Okay, and it kind of stands to reason, right? It's a complicated medical procedure. You're asking prison officials, right, to put 3 different drugs in specific doses, in specific order, into a person's veins. Okay, so the odds of being tortured to death, and by the way, if you have a botched hanging, that's also horrible, right? It's very gruesome. But the odds of it happening to you with lethal injection are triple the odds of it happening with respect to hanging, for example, or the firing squad. And maybe worse, right? Because the thing to remember too is that let's say the barbiturates don't work, but the paralyzing agent does, you could be in excruciating pain and no one would ever know about it because your body can't react to the pain because you've been paralyzed. So again, if the statistics are correct, and I don't know that they are, but what I've seen is pretty plausible. That means that right now we are torturing people to death at triple the rate we did when we hung them. Okay, now this is where I'm going to get more soapboxy, because one thing to ask yourself is why? Why do we do it this way? And I think to understand that, and again, this may be a little bit of like Fox Mulder conspiracy thinking a little bit, but I think there's some truth to it. Think of the history of execution in this country. It used to be that you would execute someone in the public square and people would be present for the execution. It was then moved from the public square to behind prison walls, where there was a smaller audience. Then from behind prison walls inside the prison, where there was an even smaller audience. And then we moved from hanging to first electric chair, then the gas chamber, then lethal injection. Now, why all these moves? Why have we seen these changes over and over since the late 19th century? I would argue that it's largely, maybe completely, for aesthetics and social control. Okay, so here's the thing to remember. When you hear the story, you may have heard this story. Why don't we execute in public anymore? Oh, because people enjoyed it too much. It was a public festival. It degraded the public sensibilities, right? And there was something to that. But what they don't tell you is that when the death penalty was in public, there was a powerful anti-death penalty movement in this country, a politically powerful one. People would run on an anti-death penalty platform and win. When there was a public death penalty, if it was botched, the crowd would turn on the executioner, sometimes try to lynch the executioner because they were so enraged at what happened. In other words, the public knew what we were doing. They knew we were killing people and were able to make a judgment. Do we really want to kill people or not? Is that the culture we want to live in or isn't it? But of course, once you move it behind prison walls, it becomes a little bit more abstract. You know, well, yeah, this guy, but he killed little Susie and he's a bad guy and we don't really see him suffering. And he's in prison. And now it's, and you know, they did the electric chair because it was the new scientific method that was going to be painless. until they discover that no, your head's getting set on fire and it's actually horrible. And then it's gonna be the gas chamber, but then of course they discover we're asphyxiating you, it takes 20 minutes, it's horrific. And then finally lethal injection. So it's not, so we've not gotten less cruel over time, right? The pain level associated with the death penalty has not gotten less. It's just that the public, it's hidden from public view. And so the public can't really make a judgment about whether it's in favor of the death penalty or not, because the public doesn't see what happens. And now here's my final point here. You could make the same argument about prison itself, right? Why have we seen this explosion in incarceration? Why do we see so many more people in prison today than we did? Well, one reason might be that we don't see them suffer, right? We don't see them suffer. They go into prison, they suffer. It's not like they're not suffering, but we don't see it. And so we can't make judgments about it, about whether it's too much, right? As a people, it undermines our ability as a people to make judgments about punishment, right? But again, think for a second. You know, we think of the Puritans as being so cruel because they would flog someone for punishment or put them in the pillory. Well, ask your typical person convicted of a crime. Would you rather be pilloried or flogged, or would you rather spend 5 years in a hole where no one can see you? I suggest many of them would choose the public shaming, the public flogging, and public pillory. And also in those colonial areas, by the way, if you look at the records, in year X, they're getting flogged. In year X plus 30, they're lieutenant governor of the colony. How often does that happen today? It doesn't happen today, because today it's permanent exclusion. You go to prison, and then you got a record. And you're lucky if you get a job at all, right? So again, I feel like I'm being a little preachy here, but it's, I want you to understand that the system that we live under is a system that's designed to protect you from seeing the suffering of the people we punish. Now, I don't know if there's an easy solution to that. Like, I don't know if we can get rid of prison or make prison more transparent somehow, make it a reality show, who knows? But I think it's a real problem. And I think the reasons some of these changes were made were not benevolent reasons. They were, the government wanted control. The government did not want to have to deal with political movements or crowds or mobs that might turn against them. And so they made it private. So some of you will be legislators someday, some of you will be judges. Keep that in mind when you become part of the system. Yes.
I wanted to ask, it's all tied in mass incarceration, but mass incarceration spikes in sort of mid to late 20th century, but at the same time, we got all of the social science documenting rates of recidivism, things like this, and then creating the phenomenon of predictive sentencing. And also that was implicated then in reviewing prisoner sentences, and looking at the pool of prisoners to which they belong and predicting that they would have, you know, a certain rate of recidivism factor that provided you with random clemency at that point. To what extent do you think that explains the rise in mass incarceration? To what extent do you think that predicting whether or not somebody is going to commit another crime, is that unusual? It's certainly unprecedented for a computer to decide, you know, your chances as opposed to having a sort of normal path of redemption.
Yeah, well, so a couple things. So first of all, I think if you look carefully at the timing of these things, so a lot of what you're describing seems to be during the era of indeterminate sentencing, where you'd have a parole board and they would try to make judgments about whether we can let you out based on the risks you pose to society. That largely predates the era of mass incarceration. The sort of, because things start tracking up in the 70s, which is the very tail end of that period. In the 80s is when we start getting determinate sentencing, both at the federal and state level, and you have the mandatory minimum sentences and that sort of thing. And parole boards are largely gotten rid of, or their role is reduced. So that's point number one. So I don't think that if you look at the numbers that they'll match, that's the reason. Point number two is that towards the end of your question, you seem to be talking about sort of what's sometimes called the actuarial method for predicting recidivism, where you basically, the same actuaries who predict your likelihood of getting into a car accident will now predict your likelihood of recidivism, and then write an algorithm to try and predict and determine how long you should be in. That's a very recent phenomenon. So in the parole board era, they would do things like interview a psychologist or something. And they have a very poor track record of predicting recidivism. Like psychologists are terrible at it, statistically. The actuarial method is apparently much better. But my understanding is that it's largely used in the context of pre-trial release questions. I don't know how much it has to do with post-trial sentencing. If it gets into the post-trial sentencing, then it might play a significant role there. Although you would expect that what they would find is that there's not a big recidivism risk for a large proportion of those who are in prison now. And so it might actually, if it were implemented, it might reduce prison sentences, but hard to know.
Just for follow-up, you said that they introduced, again, mandatory minimums in the 80s. Were those a consequence of just a historical question? Were those a consequence of understanding the rates of things like recidivism from people having too short sentences, or is that unrelated?
Well, it's sort of mandatory minimums are part of the determinate sentencing movement, which I would say determinants, and we got sentencing guidelines on that and all that. It's from an unholy alliance between the right and the left. So that everyone hated indeterminate sentences, but for different reasons. And so they decided that we need, and basically you could think of it as, the thing about indeterminate sentences is that similarly situated people convicted of crime might serve very different sentences depending on what judge they got or what parole board they got. And so there's a fairness problem where similarly situated people are getting different sentences. And so the right and the left agreed, well, we need to move away from indeterminate and get back to determinate. But what happened when they went to determinate sentencing was the federal sentencing guidelines in particular just ratcheted up. They looked at average sentences, but without considering probation sentences. So the average sentence got ratcheted up much higher than it had been from the get-go, and then state systems followed. So it's not, I don't think there was anything very scientific. I mean, sure, they tried to predict recidivism risk. It's one of the factors under the sentencing guidelines. Not super scientific, truthfully. Again, today you can do more with the actuarial method, but the actuarial method presents all sorts of other issues because it's been implicated in racism, among other things. That this method has been shown to have disparate impacts, and so it's very controversial. I don't know what effect it will have over the long run, and it's not perfect. It's just better than using psychologists. Do we have to stop? I'm happy to go as long as people want to, but I guess
If we could just put a formal stop to it, and then if you're all right with
And I
picking
can
up and
chat.
mingling and asking questions. All right. Thank you, everyone, for coming and for tuning in on Zoom or on YouTube. Really appreciate it, and big round of applause.
if anyone has more questions, I'm happy to talk for a little bit longer. There were other hands. I know you're shy. I don't think people can also leave. Like, you don't need to stay. Thank you. And you can come up and talk to it if you want to.